State having these new restrictions placed on him, being asked to go to the legislative council, it all taints the decision-making process in regard to whether or not this limitation is going to be placed on auditors. I don't have any legislative record. It appears as if there were some deal brokering going on that if the state Secretary of State was allowed to send those requests to everyone, that there should not be that this additional provision limiting the county auditors should be added on there as a condition of moving that forward. And that's an example of how the whole process and the decision-making process in regard to that was tainted by the constitutional issues.
Okay, all right. Let's go to the home rule.
The issue of home rule being limited strictly to the Board of Supervisors was raised in the motion, in the resistance the reply filed yesterday. We provided the background for that in our supplemental resistance. I do believe there is additional statutory authority that it does not directly operate in this context. It does reflect that county officials can be included under the home rule provisions. It is not limited to simply Board of Supervisors, and that there are also some Attorney General authority on that issue. Given the time constraints, I did not include all of that information in the brief, but I would be happy to supply additional arguments on that issue. Because those cases are not directly in the same context here, I chose to set forth the statutory authority, which I believe does not restrict the application of home rule to a county official. A particular county official who's been designated this express authority. This express authority.
All right, I broke your train of thought. Anything else?
I just wanted to, obviously the context of this motion is the request for a motion for a temporary restraining order. And one of the elements that has to be proven here is irreparable harm. And in regard to harm, the plaintiffs have alleged they're concerned about potential voter fraud. However, all of the references that have been provided up to this point all talk about generalized comments that absentee ballot procedures can result in fraud. We see examples presented from old studies that don't provide any direct context or analogize to the system that's in place in Iowa. Even in the resistance that was filed, or the the reply that was filed yesterday, we still see new scenarios described. Well, in Nevada, they just sent out ballots to everybody, and these things happened. And then also criticism about absentee ballots that went out in New York. There is no indication, and there's been no attempts on the part of the plaintiffs to establish that any of those scenarios were state law situations that have the same kind of system that there is in Iowa. In regard to the irreparable harm, we just have these abstract claims that there might be potential voter fraud. But in response to that, the Auditor Weipert has presented specific information in the form of affidavits from credible experts that say that even those generalized claims that were asserted by the plaintiffs are not reliable and do not apply to the Iowa system, that the Iowa system really has a reputation far and wide for having addressed these type of issues and for placing numerous checks and balances in place to avoid those potential pitfalls. We provided a detailed list through the affidavit of Johnson County, the steps they've taken to ensure that voter lists are current and up to date, including steps taken just this spring in expectation of needing to deal with issues related to COVID, and continuing checks and double checks to ensure that voter records are accurate. Also provided specific information regarding the multiple systems that are used to track persons who were registered voters who are deceased and to remove them from the system, and that continues to be tracked even if their death occurs after an absentee ballot request is sent out, to make sure that no one is accidentally voting for no one is either, well, accidentally or purposefully committing voter fraud by trying to vote on behalf of a person who's deceased. There's also detailed explanation of all the security measures that ensure that only one ballot will be mailed out to a registered voter, regardless of whether multiple absentee ballot requests are returned. And the systems in place to ensure that a registered voter will not be able to submit multiple ballots in different counties. All of those systems are in place. If somebody gets their hands on 5 different absentee ballot requests and sends them in and has them sent to their address instead of the person that they were directed to, there are ways of tracing that, and only one absentee ballot would actually be sent out after those discrepancies were reconciled. So the two hypotheticals that were presented by the plaintiff just simply are presented in a vacuum. What if somebody accidentally gets one of these pre-populated ballots in the mail at a house where the previous owner no longer lives? First of all, that person would have to have decided to open somebody else's mail and then willfully engage in voter fraud by signing the document, which has a oath provision on it, and then sending that back in. But while somebody is committing that felony in order to attempt to commit voter fraud, they would have to they would have to count on the fact that the person that it was really intended for would never ask for an absentee ballot, or never show up at the polls and ask to vote. If the fraud was detected, then an investigation would make it fairly clear where the absentee ballot request had been sent to that resulted in this problem. There is absolutely no indication that this sort of problem has occurred. Not only are there checks to make sure it doesn't happen on the front end, there are multiple systems in place to make sure that doesn't happen on the back end. Again, regarding the hypothetical family member filling out an absentee ballot request, that also does not take into account the elaborate set of checks put in place to regularly and continually update the information regarding deaths that would have occurred in the county. Also, the irreparable harm that was mentioned by the plaintiff in their petition talks about needing to manage their campaign differently in terms of voter registration and voter mobilization, but have provided no information to describe how that would, what that impact would be on them or what they would do differently. These sort of completely unsubstantiated claims should not be sufficient to establish even a likelihood of irreparable harm, and certainly are not sufficient to establish that sufficient to grant the temporary injunction in this matter.
Should the harm equation look at the fact that right now no absentee ballots have been sent out? Those don't go out until October 5th. So we're talking about applications. should the harm calculus take into account at all the real potential that if, whether I'm the last word and I say everything's constitutional, whether it goes all the way up to the Supreme Court, the last word that this directive by the Secretary of State was a constitutional action, and that comes down after people have gotten their ballots and after they voted, then the risk that their actual vote would be discounted. Because right now we're only talking about applications. What we're saying is, okay, if you want to apply, you have to fill out the information yourself, essentially. But if the decision on this declaratory judgment action comes down against Mr. Weipert, after someone has submitted one of these pre-populated absentee ballot requests, got a ballot and voted, and the remedy there could potentially be vacating that vote, is that something that should be considered as far as this harm analysis?
Well, Your Honor, I don't believe that just simply the fact that an absentee ballot, a pre-populated absentee ballot request was sent out would be a basis for invalidating someone's vote. If somebody
if the answer down the road is the Secretary of State's order authorized by the Legislative Council was completely lawful and constitutional, and these pre-populated absentee ballot request forms were invalid, so then anybody who used one got a ballot and voted with that invalid request, isn't there at least, no one's throwing out any votes, no one's voted yet, no one's casted any absentee ballot, no one's gotten an absentee ballot. So the fact that we're dealing with this potential problem before anybody gets to vote versus after, is that something that should be considered in the harm equation or not? And I know you don't agree that that would be the remedy. I'm just saying is, this isn't declaratory judgment action. This is a request for an injunction, and the injunction rules are different, and you're going through what's required, and you're right on point on that. I'm just asking about that one particular analysis.
I do not believe that there is a basis for determining that somebody's vote would be invalidated based on, but if the court feels that that action was unconstitutional, then the court has an obligation to find that unconstitutional. There's also a very substantial potential harm that could result if this statute is not called out as being and this process is not called out as being unconstitutional. All sorts of other changes could be made to the election procedures that could wreak havoc in the next 2 months. It's a travesty that this provision was added in there, because it really leaves a power open there which should never have been granted, and that certainly is a very serious and potential consequence to moving forward and validating the constitutionality of that directive.
All right, anything else? We're getting short on time, and I got to give Mr. Ostergren another opportunity to respond to some things. I have a couple questions for him.
I also just wanted to briefly address the claim of the dilution that somehow by sending out the pre-populated ballots that this creates some sort of dilution of the vote. If the court is concerned with that as part of the calculus, the fact that the 2643 places a huge disproportionate burden on large counties in terms of complying with the requirements to correct any information. Absentee ballots are coming in from all sorts of different entities, and that duty remains. The calculus there that smaller counties that don't have that volume would not be particularly harmed in this manner, because they would be able to, even if they didn't send out pre-populated forms, they would be able to go through the procedures and would be able to handle that in a manner that would not be able to be handled by large counties. The harm analysis obviously spills over to the balancing harms issue, and so I think we have address some of those today, but I'd also ask the court to consider that I believe that the prior rulings have indicated that the expenses incurred by the auditor's office in order to comply with the temporary injunction should not be factored into the balancing of harms because the auditor had taken some action that was unlawful. Given the stance of this action as a temporary injunction, the harm, if it would turn out that it would be determined that Auditor Weipert's actions were lawful, would be the cost incurred in trying to do these corrective actions and should be considered into that calculus. We have significant numbers in terms of the cost and also the personnel time, and that is compared to the generalized harm prescribed by the plaintiffs, and would ask that the court find that they have not, the balancing of harm does not warrant this extreme remedy. Just notice a final matter that we have included a copy of in one of the declarations, the sample ballot, and it's important to note that any person who was signing this does have to sign under oath.
You mean sample application? You said
yes.
Sample ballot. I just want to make sure. Sample application.
Pardon me?
Yeah, that's right.
I made the mistake that it's frequently a sample application that shows the fields that would have been filled out in a pre-populated absentee ballot request. I'd also note that although I think the record was somewhat ambiguous about this issue, that at no time were anybody's driver's license numbers or their non-driver DL numbers sent out on any of those pre-populated forms. And as the affidavit reflects, nearly over 2,000 people have returned those absentee ballot requests and have filled in the specific driver's license information or non-driver ID number on those forms. Obviously, the situation that we have, the COVID crisis has created a host of issues that have to be dealt with here. However, we ask the court not to throw aside the important safeguards that have been put in place that put checks and balances on how the authority can be exercised. Although the complaint of the plaintiffs is the auditor's actions validating the inappropriate use of power and the undermining of the administrative rules that exist, that currently exist, is not the answer to moving forward, and that given the way the current statute is written, the auditor reasonably believed and could be reasonably within that statutory language. There is no express prohibition, and the actions to pre-populate those documents were within his lawful authority. Thank you.
Thank you, Ms. Neary. All right, Mr. Oskren, I'm going to let you respond to that. What I want you to start with is the defendant's assertion that your entire request is based upon the Secretary of State's order and the lack of abidance thereof, and has nothing to do with the provisions under 53.2 sub 4 that went into effect on July 1st.
I think those are overlapping issues, Your Honor. What I sensed you were getting at with counsel is, and in fact I think you posed this hypothetical in essentially these terms, that suppose the emergency election directive had not been promulgated and yet the auditor still wanted to send out these pre-populated ballots, would there be the same harm? Would there be the same underlying basis for a declaratory judgment and an injunction? And I think the answer is yes. Now, our action being predicated on the Secretary of State's authority, in our view, is a much simpler path to get to that declaratory judgment and that relief. Well, I'll stand by what I said before about the ability of the auditor to contest the constitutionality of a statute. I don't think it's a good look when a elected official says, well, I just don't think that process was right, and that law makes sense, so I'm not going to follow it. Which is essentially the argument that counsel made. She used the word travesty to describe the statute passed by the legislature to give the authority to the, or to require the use of information from the voter to complete an incomplete absentee ballot request. In a sense, counsel's correct that the language of the statute does not expressly prohibit the auditor from sending out a pre-populated ballot. But that is a very strained and almost, I wouldn't even call it a literal reading of the statute. I would just call it a strained reading of the statute. How clearly does the legislature have to speak in order to instruct a ministerial official how to execute his duties? And when they tell Mr. Weipert that if you get an incomplete form, you need to get the information from the voter. You can't just get into the database and guess who sent this to you and send out a ballot. Does that mean that he can just ignore what the legislature is trying to do with that and say, I'm going to send out all the information from the database at the front end so that we never have to worry about this statute and these duties?
Let me ask you this. Could Mr. Weipert have sent a letter, dear voter, with PIN number or whatever, enclosed as a blank absentee ballot request? You're going to need this information to fill it out. Could he have done that under 53.2 sub 4? Instead of putting the voter PIN and the address, the birth date, and really here the issue, I think, people know their birth date for the most part, right? It might be the PIN might be the issue, but if he hadn't put it on the request form itself, had it been in a separate letter, would that then have been all right under 53.2 and the directive?
So I can tell you that sending the voters originally got their PIN through a letter.
Okay.
So I don't want to defend the territory that they can't be sent their PIN by a letter.
They could have been sent their voter registration card too, presumably, right?
And I think that would have been the form originally. So when that statute went into effect, and I apologize, I think it's 2017, but I could be off by a legislative session with that. In summary, the state took the list of everybody who's a voter and the list of everyone who has a driver's license or a non-operator identification card, and the names that were not on the DOT list got kicked out the PIN. Now, my understanding is in the system, everybody has that 4-digit number. If you have a driver's license, for example, most people are just going to pull out the DL and fill out the absentee ballot request form using that number. But everybody has that 4-digit number in the system, in that iVoter system, to be pulled out and sent to the voter. So it is a very interesting and difficult legal question. If the Secretary of State's directive never existed, would we be here in court today? That it is a much more nuanced legal argument, going through what does the voter get supplied by the auditor and then turns around and provides back. I think the court is correct in saying it is an extremely strained reading of the statute to say the voter has to provide this information to get an absentee ballot, when in fact all the voter is doing is making a mark on the signature line and sending back what the auditor has provided to her. But we do have the Secretary of State's directive. And I think the thing that is so important about that directive that is easy to miss out on here, and that is the need for statewide uniformity. The directive recites certain findings about the challenges of COVID-19 and the desirability in this cycle to have people vote by absentee ballot if possible. And to facilitate that, the Secretary of State is going to send out the blank absentee ballot request form. And his directive says not all counties in our state have the financial or technical, I believe is the term he uses, technical or maybe logistical, I don't recall exactly. But essentially, the money that it would take and the practical skill, IT support, what have you, it would take to send out everybody in their county who's an active voter a blank absentee ballot form. And because of that, because of the need for uniformity statewide, the Secretary of State says, my office will send a blank form. If county auditors are going to send out forms, they have to be blank also, because he's maintaining that level of uniformity statewide, so that a voter in Johnson County, as near as possible, is being treated the same as a voter in Jones County or Adams County or any other corner of our state, large counties, small counties, urban, rural. We don't have that disparity where urban counties who have far more resources and far more technical ability, likely in an auditor's office or working with vendors, can send out things in a way that smaller counties can't do. So that need for statewide uniformity is the driver behind the Secretary of State's directive to all auditors. On the administrative law argument, I'm not the greatest note taker in the world, and maybe counsel didn't mean this. But in talking about the emergency election directive, what I wrote down is that she said it's not a statute and it's not an administrative rule. And then we had a long argument about how if this is an administrative rule, it doesn't fit into the legislature's power to nullify administrative rules. Well, we agree with her, this is not an administrative rule. But the fact that it's not an administrative rule means Article 3, Section 40 is totally irrelevant to this issue. Yes, the legislature, by joint resolution, can abrogate an administrative rule. They maintain that control over the administrative law process. And the Constitution spells that out, and that's why the legislature can act in that way without the governor's signature on a law. Because if the governor agreed, you could just pass a law and nullify a rule that way.
So are you saying, what are you saying is not a rule? The directive or 47.1?
47.1 is a statute. What I'm saying is the emergency election directive is not, for purposes of the Iowa Administrative Procedure Act,
Okay.
is not a capital R rule as in defined in administrative law. It is legally binding, and I have cited the definitional portion in 17A, which recognizes that the statement of an agency that is for a specific set of facts, which is not of a permanent nature, is outside of the definition of an administrative rule. And that's exactly what we have here. This emergency election directive applies to the upcoming general election this year. This is not a permanent change in Iowa election law. So it is not the kind of thing which belongs in the administrative code. Now, there are administrative rules about how you handle emergencies. And yes, some of those emergencies are natural disasters, and that makes sense. We should have a rule decided on in advance that if, say, the day before an election, a tornado destroys a polling place, everybody knows in advance what, the auditor needs to call the Secretary of State and says, hey, that polling place got knocked down by a storm. I'm going to put the polling place here. This is how we're going to notify people. The rules are all spelled out. Sending out absentee ballots and maintaining ballot request forms and maintaining statewide uniformity is just a fundamentally different thing. And so, of course, it doesn't fit into the Secretary of State's administrative rules that he's promulgated in advance, because it's not like a storm knocking over a polling place. Now, there's an argument essentially that there's something inappropriate or almost unsavory about having the Legislative Council weigh in on that. I would say that that's good government, that it's not just the Secretary of State on his own saying, this is how I think we should change how the election's going to work. He consults with the body that represents the legislature's interests and gets their approval, in this case, of what the emergency election directive is, as is spelled out by state law. And
Do we know what that vote was? The Legislative Council?
the unanimous to approve the directive as it exists. There was an effort, the minutes are available online. There was an effort to amend the directive several times that did not prevail in votes, but then the final approval of the directive is unanimous. That Legislative Council represents basically its leadership, majority and minority, House and Senate, along with the chair and ranking member of the top committees, probes and Ways and Means and whatnot. Unanimously passed by the Legislative Council. I want to, the court, I think, identified the danger of harm here if nothing is done. And I want to be clear, the plaintiffs do not want to see absentee ballots get challenged in November. If you look at, and I've cited, the procedure by which that would happen, it would be up to Friday before the election at 5 o'clock, any elector in this county could come in and say, I challenge this absentee ballot, or I challenge these 10,000 absentee ballots, or what have you. And then the auditor has to essentially summon those voters, and then there's an abbreviated hearing in front of a special precinct board to weigh those challenges. And if we have a system with essentially this ticking time bomb in it, those challenges prima facie have merit. There's no way to know that the person who sent back that pre-populated absentee ballot request form is the actual person entitled to vote. And
Doesn't the signature tell us that?
well, the auditor is, and this case is cited in a footnote in our original brief, Your Honor. No matter how flagrantly inconsistent the signature on the absentee ballot request form is with even the signature on the security envelope that would hold the absentee ballot when it comes back, through a district court decision in Polk County, auditors cannot do any kind of signature verification. You can't look at the absentee ballot form and say somebody made an X with a crayon, and then somebody else sent this ballot in and signed it with a fountain pen. Gee, I wonder if I should challenge this. You can't do that. So I'm not here to trash Iowa's election system. That's not the purpose of it. But there is an inconsistency in the argument that my learned opponent made. We have a great election system that's rigorous and robust and protects the vote. And there's lots of parts of this election system that we don't feel like we want to enforce, and so we're not going to, unless you make us. Those things don't add up. The legislature creates an election system by passing laws as to how this will work, and people like the auditor of this county and his 98 colleagues have to follow those rules. They don't get discretion about this rule is really important to me, this rule is not important to me, I'm not going to follow it. And the statute clearly says the election official elected over them, the Secretary of State, gets to supervise them. Now, I agree that Paul Pate cannot show up at Mr. Weipert's office and say, you know, you're fired, or, you know, your lunch period is from 1 to 2 p.m., and we're going to move this desk over here. He doesn't get to do that. But he gets to issue orders to the auditor. And under our system of election administration, when the state auditor, or excuse me, the state Secretary of State issues an order to the county auditor, the only legally acceptable response from him is, yes, sir. And that's why we're here in court, because he's not obeying the order that he has been given. That affects the election system, that we have a candidate on the ballot as a plaintiff, we have candidate organizations, and we have a political party. We are competing in every county in this state, and we are entitled to have a uniform system of election administration, not 99 idiosyncratic systems. And that is the basis of our claim here. On the question of bond, I think we've briefed that pretty thoroughly as to the access to court issues that are presented. According to the auditor's declaration, not all of these requests have gone out yet. And so it would cost nothing to not send those out as one part. So the court could grant substantial relief to us at no cost. There are also presumably going to be voters registered between today and the election who the court can order to not be sent a pre-populated ABR form. But fundamentally, the purposes of uniformity, I think, tip the balance towards clawing back all of these unauthorized ABR forms now, so that these voters can get a letter, they can get a proper form, they can send it back. If they still want to vote absentee, they can do that. And then ballots will go out October 5th, and will keep going out until shortly before the election. We can fix this now. This is a small problem now. It's a huge problem if at 4:59, the Friday before the election, somebody walks into Mr. Weipert's office with a binder full of challenges. That's a big problem. Let's not have that. Now, I'm not saying we're going to do that. I want to be clear on that. But any voter in this county can do that. It doesn't have to be something organized by a candidate or a political party. Anybody in this county could walk into his office and drop that binder on his desk at 4:59, the Friday before a presidential election, and throw this election system into chaos. We need to avoid that. We do not want that in any way. One last very minor thing on the question of bond, Your Honor. If you grant the injunction and you set a bond, I would ask that the court set it in just simply a nominal dollar amount. When Your Honor says cash, the clerk of court is literal as to what that word means, and so a couple weeks ago I had to go bring $500 cash to the courthouse, and if you grant the injunction, I'd like to just send a check. So I would make that request for the order on that. With that, I don't have anything else. If Your Honor has questions, I'll be happy to answer them.
Well, you've addressed some questions I asked and ones that I was going to, so we're good on that.
All right, thank you, Your Honor.
Have a seat. Ms. Naring, I'll give you one last brief chance. It's Mr. Ostergren's motion. It's his burden, so he's going to get the last word regardless. So if you have something else to tell me that you haven't already mentioned, based upon what Mr. Ostergren said, I'll hear that. Otherwise, we're done.
Sorry, I just do have a couple more remarks. Sorry, I just want to check one issue here.
Okay. Mr. Neri, I'm just going to have you wait a second while we change some paper here, so take your time. Go ahead, Ms. Neri.
Your Honor, there is nothing in the statute that provides a requirement that the voter themselves has to fill out all of the information. There's all sorts of political parties and various other nonprofit groups that are sending out various different forms. And there's nothing in the statute that clarifies that they could not provide, that they could not populate some of the information on there, particularly information that is not confidential. The fact that the statute is silent on this issue is exactly why the directive, why there was a need to have the directive issued. If the statute was clear, then there simply could have been an order from the Secretary of State saying that you were in violation of the statute, and that is not what happened here. I just wanted to have an opportunity to submit one more document. We did obtain an affidavit from one of the members of the Legislative Council regarding the history of the decision. In addition to the minutes, there's she reflects that her eventual vote was based on her concern that the Secretary of State would not send out the absentee ballot request to all of the registered voters if the directive was not approved in its entirety. We had some difficulty getting a good copy of that document, and we're still trying to get that finalized today. We have a copy that is legible, but would ask permission to submit that as part of the record.
Do you have any objection to that, Mr. Ostergren?
Not on foundation?
Any objection? Foundation, I doubt there's a foundation issue. I have no reason to doubt what Ms. Neri's telling me, but
Nor do I.
there's a timing issue, there might be a relevance issue, I don't know. Do you have any objections?
So, Your Honor, I have Westlaw here on my iPad, and I was just about to, my belief, but I cannot cite a case to you, is that a legislator's, there's case law that basically says that a legislator's after-the-fact statement about what a law means is not relevant to a court's analysis of what the legal effect of the language is. So
I don't think this is what this tells me. This tells me why a particular legislator on the council voted. So it seems like it's doing even less than what you're addressing there.
So
I don't. I'll take it if you don't have any objection. If you have some objection, I'll take it subject to that objection and think about it. Again, at this point, I don't really know why it's relevant, why someone voted yes or no on this. I just simply asked the question, do we know what the vote was? Because I was curious. I don't think that matters. If it was a one vote win, it's still an authorization from the council. I don't think that part of it matters. So I'm not sure why it matters that a particular legislator voted yes. We have the directive, we have the approval of the council. Those are I think are the factual pieces that I have to consider. I don't think what the vote was or who voted for what matters to the ultimate question. But again, I'm either going to take it with no objection, or I'm going to take it subject to whatever objection you raise, and then determine if it actually informs my decision at all.
My objection purely would be to the legal effect, and I would have said what you just said. In terms of the document itself, I think it is what council says it is, and so I'll object just simply to what legal effect you should give it.
All right. Ms. Steering, I'm going to go ahead and have you upload that as a proposed exhibit. I know the rest of your documents are attachments to your various pleadings. I guess I'll leave it up to you. You can either file it that way, or you can file it as a proposed exhibit, and I will take it subject to objection and whether or not it means anything to the issues that I'm trying to decide here as far as this injunction. Okay?
Okay.
All right. Anything else?
No, nothing further. Thank you.
Mr. Osterkin, last word. Anything else? No. All right. The court is going to take this matter under advisement, and I'll issue a written ruling when I've come to a decision. I can't promise you when that will be. I can only promise that it will be as soon as I possibly can. It'll become no surprise to the council here. This isn't the only case that the court has. This is not the only case that's going on in this district right now that is complicated and involved. So we are going to get this out as fast as we can, but it's not going to be by the end of the day today, I can promise you that. And with that, we're in recess. Thank you all very much. Don't forget to put your mask on before you head out. Go ahead and carry